You have completely destroyed the judiciary.
No, sir, we are getting the signature of the judge. It means that our Judge Sahab has become a party to it. Look, madam, please listen to one thing. Sir.
We are showing a lot of patience and civility towards you. Do not make such allegations. No, that amounts to contempt. You are inviting another case. Your statement that whatever happened there will also happen here? Let us send you to jail right now and take the case and send it to another bench.
No, sir, we should
not talk like this. We made a
mistake, sir. We are showing full intelligence that no innocent person should be punished unnecessarily. And we will sit here with the presumption of innocence of a person who is appearing before us.
Sir, it is
not the allegation against you that for 10 years you were feeding him slow poison. You were giving him arsenic little by little and he died because of that. Sir, it is said in number 13 that suspension, however grave it may be, cannot take the place of proof, and there is a large difference between something that may be proved and something will be proved. So this is what you said. It's 14. Another golden thread which runs through the wave of the administration of justice and criminal cases is that if two views are possible on the evidence adjudicates in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. This principle has a special relevance in cases in which the guilt of the accused is seen to be established by circumstantial evidence. Sir, one, this is Rio Lordship, and the other, sir, no, we could not read it yesterday, let us read that by Sharad Budachand, sir, read it today, read it, sir, in that it is written that this is the entire case based on circumstances. Yes, 153, sir. This is written by Nagendra Sahai. We are reading from that. 153 of Sharad Chandra Sarda versus State of Maharashtra. A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of the guilt is to be drawn should be made. Just today, you had read it and told me,
yes, it is okay.
Sir, read the point and tell me, yes, it is okay, sir. Yes, it is okay, sir. Your Lordship, if you will allow, sir, we can read for 2 minutes on the post-mortem report.
You can tell us whatever you want to say comfortably.
We want to say this, your Lordship, that we did not know that was not on record. He will not get it here. We want to say that on page 85 of the post-mortem report it is written that from this part our counsel has not asked about it. But the police has asked.
What is written?
The post-mortem position. We are just telling you without seeing it. On page 85, sir, it is written that from those parts why there is a little smell, normal smell and severe smell coming from. All this has been asked by our counselor. But the police has asked. Wait for a year. Where are you studying? This page 85, sir, post-mortem report.
Yes, the policy in it.
Yes, so in this last paragraph, the printed type written is the query of the police. Was he hot or cold or stiff or alive or dead? From which organs was the liquor coming out? So, your Lordship, this is the query of the police. Yes, our counsel did not ask, the police asked, so they have not documented that the smell is coming from other parts of the body. So, sir, your Lordship, it has come on record that there was no found smell. Then, sir, on page 70, Dr. D.S. Bagal has said that vomit passes within 6 to 12 hours. Maximum 18 hours. We have already done it, madam. We have argued in detail.
Yes, so we had stopped saying this. The
cooler was not working. The exhausts were closed. There was no smell. Yesterday you only spoke for half an hour. The point has been made. Yes, okay, sir. Sir, your Lordship. So, in this, our case law which we are telling you is, Sai versus State of Bihar. These are two case laws. Please give me its 23, sir. In the decision of Nagan Sahab vs. State of Bihar, the Honorable Supreme Court has said in para 23 that what survives for the consideration is only an opinion of the medical practitioner who conducted out of C&K government report on the cause of the death as held in the case of Balaji Guntu Dule. Supra only on the basis of postmortem report, the accused could not have been convicted of the offense punishable under Section 302 of IPC and certainly for the offense punishable under Section 2001 of IPC. So sir, postmortem report, your lordship, cannot be the sole basis for the conviction. That was our only request to you, sir. Now, sir, we have given page 13 written arguments in this. So you sit down and do your work. No, page 13. GGG, your lordship, page 13 is written in memorandum recovery of the articles under Section 27 Indian Evidence Act and a waste of the appellant. So your lordship, if you read completely what is written in it, then it will take time. In short, we want to tell you that the police had taken the memorandum at 11 a.m. Memorandum page 24 is Memorandum Exhibit P4. So sir, keep on saying.
Let us see P4.
Yes, sir. The
Page number of the paper book is
Not with us, sir, our lordship, we have not got it. It is not in the paper book.
No, it means that the exit must not have been taken. Exit P4 is there.
many.
Uncle. In the paper book.
Yes.
We also, yes.
Lord, on page 14, he has taken us, meaning the memorandum, only at 11 o'clock.
And the recovery page is Exhibit P415. Exhibit P15. The recovery of the articles. That was done at 12:30.
Yes.
12:30, and the next exhibit is P7, in which he has told that we were arrested at
134.
Yes, at 13:10, so sir, your lordship, and the fur was lost against an unknown accused. So at that time I was neither in the custody of the police and I was accused of an offense. He said, sir. Wait a minute, then. I am in the custody and the acquisition of an offense, which are the essential requirements for the admissibility of the memorandum and recovery of the articles as evidence under Section 27 of the Indian Evidence Act. Father, sir, this is his exhibit P15, your lordship, he has written in P15. P15, exhibit P15 has been written by him. This page is presented by the accused from the Sringar Dani, Sringar box, kept near his house, meaning the articles were kept on top of the Sringar Dani, Sringar box, and were recovered. So your lord, we just want to say that they were not hidden at anywhere. They were kept on the Singar box and the police has already visited it. What we
want to say is that the one who had come earlier, had visited, had prepared the spot map, so it comes to the notice of the police. Sir, it is not by mistake. We are understanding your argument. Yes, please tell me, madam.
We are saying this, so these were not hidden anywhere. S per se season memo of the X. P15 and police already has bid 2 times at this place, on the 1st of May for preparing the mug investiture and body panchnama and sending the body for the postmortem and second time on the 6th of May for preparing the spot map. So twice police at the same place has bished it. So, that was not a discovered fact. And for this, Lordship, this is the case law. Allah Raka Habib Menon versus the state of Gujarat, on the 8th of August.
Allah Raka.
Allah Raka. These are his. And Rajesh versus both of them are to be given. Give them separately. Sir, in that black has come in the photocopy. So sir, Rajesh versus in that, which is written in paragraph 26, which we have requested to you earlier that I was not in the police custody and neither the accused of the offense. Read this sir, what?
Read it.
Okay, in 26 it was observed that the condition necessary to bring section 27, we are reading it in 26 paragraph sir, we are from 20, right? Enu operation is that the discovery of a fact and consequence of inaction received from a person accused of any offense, in the custody of a police officer, must be deposed to, so both these conditions were not being fulfilled. When his recovery happened, also your lordship, a lot is written in it, but he has written, that letter from the will, that this is in 28 next it is written in it that whatever has to be read sir, then behind. If you want to
tell, then read it, don't tell.
No, you have to tell sir. Because of the time, we really found them, and that's it. These black guards against possible. The primary intention behind the panchnama is to guard against possible tricks and or dealings and unfair dealings on the part of the offense interested with the execution of the search, and also to ensure that anything incriminating, which may be said to have been found in the premises by search but actually found there, and was not introduced, are planted by the officers of the search party. It was further noted that the legislative intent was to control and check this malpractice of the officers by making the presence of the independent and respectable person compulsory for search of a place and seizure of an act. Okay sir, it is written below. It was pointed out that panchnama can be used as cooperative evidence in the court this and this who is the witness. What is it in our case sir, the 2 independent witnesses, how were they not independent? We will tell you about this later sir. No, tell us right now, they were not independent.
Okay.
Who are the witnesses of your seizure? Yes, so we are telling you sir. These are the panch witnesses. We have said this, it is written on page 14, we have given that in writing. We have given an application to panch witness serial number 66 your lordship kindly see the page 40 of the paper book.
Paper page 40.
Yes sir. What is page 40? Page 40's paragraph 4.
Sir,
this is panch witness. I am educated till intermediate regarding recovery. It is true that I had taken admission in BA, but could not complete my studies. It is true that a case was filed against me during my studies in college. I voluntarily said that it was a false case. It is true that that case was of 307 Barsa. I do not know that at that time accused Mamta Pathak used to teach in the same college. It is wrong to say that Mamta Pathak scolded me and called the police and got the case registered. It is wrong to say that from that time I have a grudge against Mamta Pathak. It is true, see your lordship. It is true that my father was in the police, who has passed away. It is true that after my father's death, my brother was appointed on compassionate grounds in the police department. It is true that my house is near the Civil Lines police station. Now, your lordship, for this, see page 39, Lordship Civil Lines Colony. On page 39, his address is Civil Lines Colony, and Civil Lines Colony is the colony built for the policemen posted in the Civil Lines police station. So, he lived in the same colony. And he was of the age of 42 years, and he was living with the brother, meaning dependent person of a policeman who was posted there.
How will it happen? Where have you been asked that you are dependent on your brother, so you do not exist as an independent witness? Where have you asked this? But he said that.
Whoever has taught you and sent you here has made a small mistake.
No sir, no one has to teach you. We have said no. The good argument that you are making is somewhere the lawyer's advice to you. So, he has made this mistake in the argument that he has taught you.
Yes.
Police line, he used to live in civil lines.
Yes.
And a police officer is his brother. So, where did he give such a suggestion to him? The police will had to give this suggestion to him that you are not an independent witness. You have met the police people. You have come to give statement on their request.
This is the suggestion given below. It is wrong to say that whenever the police was needed, he denied me for testimony in Civil Lines police station. He did deny it, right? All right. It is wrong to say this. Where did he say that you are a pocket witness of the police? He must have said this. That is why he denied it.
Okay, never mind. Tell me more.
Sir. Okay, so it means that this 100 CRPC, section 100 CRPC sir. This is a violation of the same and the other witness is your lordship Bilal Khan.
Wait a second. Bilal Khan, CRPC. See the legend of 27 when the operation was done, your
Lordship, now this.
You are not just page 39, page 39. In page 39, the
examination of Chief.
This PW no, sir, sorry sir, I made a mistake, sir, page 39, no sir, this page 34, I made a mistake, sir, page
3.
We are the ones who are making a mistake, yes, it is.
page 34.
Yes.
This, it's para 1, your lordship, last line, at the time of reading the account, another friend of mine, Samayam was also present. So, now we are not talking about that he was not the independent witness and he was his friend. We wanted to tell this and then on page 35, he has again said in para 4 that I have studied up to 10th standard. I was called to the police station on the 8th of May. I was sitting at Samim's place and drinking tea. Then the police called me from there and took me away, right? And it is true that below that, after 5-6 lines, it is written. It is true that at the time when we went to the police station, the coronavirus was going on, and then at the bottom, in the last para 4, it is written. It is true that even during the corona period, I went to Samim's place to drink tea. So we want to say that now that Samim Khan was the family member of a police witness and Bilal Khan was his friend. This is our request, sir. Now next is sir, this lordship on page 15 itself, sir, no lawyer has taught us this. We have read a lot of these. It is
good.
Sir, many judgments are angry, sir.
No, we are not angry at all. Let us tell you.
What is next? Sir. Sir, the discovered articles are not found linked with the death of my husband and me, sir. The items that have no correlation with the death of your husband were not found linked with our husband's death by the FSL report. So, it was discussed yesterday itself that no written or opinion was given for olanzapine tablet. Sir, what has happened in this case? Sir, you know what generally happens. In general, what does the prosecution do? It gives concrete evidence and the defense creates doubt in it. What has happened in this, sir? The prosecution created doubt, while we have concrete evidence, sir, against the prosecution story. They did not give any concrete evidence, they just created doubt. So he said that olanzapine tablet is for sleeping purposes. They have not given any concrete evidence about this. Okay. And when the auto surgeon was asked, sir, tell me, will you read this?
Whoever wants to read it.
Yes, page 8 of this paper book, page 8 of page 8, sir, read the first 6, yes. And I cannot give complete information about olanzapine tablet. I am independent and do not advise the patient to use this tablet. I cannot tell whether the said tablet is given to patients of anxiety and blood pressure or not. I voluntarily said that I am a surgeon and do not see blood pressure patients. If the patient faces blood pressure problem during the operation, then the treatment regarding blood pressure is done by the panel anesthesia doctor of the operation. So this means that he was the best of the medicine. He knows he must know about this medicine, but he hid the truth that it is not the sleeping tablet. Okay. Then after this, it was discussed yesterday that they have given a qualitative report. Sir, we had applied to call the FSL officer, but he was not called because we could not ask many questions. And sir, one more thing I want to say is that after 4 to 5 hours of death, all the vital processes that happen diminish. They end. So, the quantity in which this tablet would be in his body, because there was no defecation, it was excreted through urine or through sweating. So, all that had stopped. So, whatever quantity of tablet would be there, it should be there. Sir, now for this we will request you, sir, that page 98, at page 98 of the paper book, whose statement is this? This is his report of lordship. Yes, it was.
Found on the Prochel.
Yes, oranzapine was found and the tests of chemical poison were found negative. Now if it is in large quantity, your lordship, then +++34+ would have been put in positive, sir, your lordship. Madam, tell me one thing, sir.
Where did the recovery of the bullet take place from, your
lordship? There is a lot of contradiction in this also. In the memorandum, they are saying that the bullet was kept in the kitchen. Sir, we are telling on the basis of memory that the bullet was kept in the kitchen, and in the seizure memo, it is being said that it was kept on top of the makeup box. After this, they are saying that the bullet was found from above and the wire was found from the dress. There is a lot of contradiction between the place of the finding of that, sir. Did you read it? Okay. We have read this and this, now your lordship, now page 1001, your lordship please page 1001 of the paper book, we are reading that, sir, there is a lot of difference in the finding of that. Tell me what you want to read.
Sir, there is time binding too, so read it today, just finish it by 4:30, tell me.
Whatever you want to read it.
Right now, sir, see 1001, sir, 1001.
Sir, it is written in this. In this we have Exhibit P23. Exhibit E is red and black colored double insulated wire. On one side of these, two white colored pins are attached. At present, their total length is 400 centimeters and the thickness of one of these wires is about 3.1 millimeters of insulation. Both the wires are made of multi-strands thin wires of metal like copper. On testing both the wires separately with multimeter conductivity, continuity was found in them. Now our point to your lord is that in this, he has written that red and black colored double insulated wires. This means that there was no one a part of the wire was stripped or the uninsulated. If this was then they will certainly when they have mentioned the thickness that its thickness is 3.1 millimeters. So why not should they also write that this much wire 1 centimeter 2 centimeter was peeled stripped so if in season.
Sir, we have
given 11 meter length in season at 1569 sir, if
it is
peeled from 11 then read it empty. In the C's memo exhibit read C's memo exhibit P 50 grams.
P 50 grams, it is written that this back one has a red and black colored wrapped extension with two pins on one side, on the other side of which end, the length of which is 11 feet. Right now there is a lot of that in it, sir. They have told its length to be 400 centimeters. It is equal to 13.33 and here they are telling that it is 11 feet.
Okay?
And how can this lordship fully insulated wire cause electric shock? If it was not peeled or stripped, that is what I am telling you. Please read Exhibit P15, Exhibit P15. Yes. So in this I am in seizure yes so loveship in this also.
One end is open. Yes so no.
Sir so it is open but fully insulated in this it is open so they also. Fully insulated means madam that the rest of the wire is not naked there is a layer of insulation on it.
Yes it does.
Not mean what you are trying to tell that. If the wire is fully insulated then no current could have flown through it so to cause any injury to anybody we are trying to say this but when we go through the seizure memo then the seizure memo says that it's an 11 feet long wire on which there is a 2-pin plug on one side and the other side is open. Another side open means that it is not fixed to any instrument and that is free to be used.
Yes but sir if it is not open then sir that was the reason that in the FSL report did.
You ask PW9 that there was any such point in that wire there was no electrical connection so that the current could be touched.
Sir, so what happened there sir? Will the same thing happen here as well sir, if you
look at that. Madam please listen to one thing. We are showing a lot of patience and civility with you, don't make such allegations, no. That amounts to you inviting another case. Your statement that whatever happened there, will the same thing happen here as well, it amounts no. Sorry that's an allegation and contempt. We will send you to jail right now and the case will be taken up and sent to another bench. No sir, we don't talk like this, you made a
mistake, sir, we want to know that the investigation is not correct.
Try to be over smart.
Sir, you are not inviting trouble, we are showing full intelligence. We want that no innocent person should be punished unnecessarily and we will sit here with the presumption of innocence of a person who is appearing before us. But the way you have said, will the same thing happen here as happened there? That amounts to contempt. No, our son is sitting outside sir. I said this in worry. Please
call his son inside and make him sit.
No, I don't. No, I will not tolerate this kind of nonsense argument. Sir, I made a mistake. I made a big mistake sir. Please forgive me sir. Go
ahead.
Yes, don't
waste time. Yes.
Now where are
you going to?
Worry. Similarly. Yes, I said in worry sir. What is going to happen sir? Secondly, sir, this was not open, that is why he did not tell which metal it was made of, And how many multists have been
written, in that you were making wrong argument. Copperage, please come back to page 101.
Yes, sir, of a metal like copper.
Yes, and until the metal cannot be tested by color, you are a student of chemistry. First, any object is
seen from its color, smell, physical shape. After that, analysis is done, test is done, then it is decided. Whenever the police sees gold jewelry, they say that the gold-like metal is brass. It will be known in the test whether it is gold. Sir, I made a mistake, sir, and secondly, sir, we want to tell you that, sir, we are drowning. That is why we are trying our best. No, you try your best.
You have not made it for that at all.
That they did not report exactly how many wires were there from those multiple wires, sir. Because they were not. It is written that both the wires were of copper-like metal, meaning it was to be of 2-4.
Wire.
What is a wire? When there is a wire, it is inside the insulation, then there is a single stand, 2 stands, 3 stands, multiple stands, they cleared it, 2 wires of copper-like metal, meaning there were 2 copper wires inside the insulation.
Yes, sir, your lordship is fine. Then, sir, we want to say that, sir, we have given Modi's book.
Yes, Modi, tell
us, sir, we made a mistake, sir, we do not panic. No, you sit for 5 minutes, do not panic. We want to give you a fair opportunity. I did
not hear this allegation, sir.
No, sir, I made a mistake, sir. I want you to wait for 5 minutes. Please sit for 5 minutes. No.
Sir, we will
tell you. What is Modi's book showing? This metallization.
Yes, tell me.
What is metallization? Page 560. We have put the owner in it, in which your return argument, yes sir. Let's see, on this page number 22560, there is paragraph 1 metallization. Wait for a minute, please brother 60 of Modi. No sir, we said that. What is its internal page number? We said our own page number. Tell me its number. Yes sir, that paper was not found. What should we?
Do, it will be below, ma'am. See, yes, I found it.
Sir, I found it. Let's keep this book. This metallization on page 35. This.
Your lordship on page 35. Page 35.
Your lordship, it is written in it that metallization is a specific feature of electric injury and lightning stroke. Then we do not read it completely, sir. Metallization is most of the marks. You will not read this also, sir. Metallic particles may get deposited in an electric word mark due to contact with metallic conductors and 2 joule heat burns, etc. Sir, this is what we want to say in this. This is due to the volatilization of the metal particles which are driving into the skin. This can occur when medium voltage of 220 to 240 volts is passed through the skin. This is what we want to say in this, your lordship, that when this wire is there, it gets deposited and the tissue gets deposited in the wire. Where is it written that tissue particles, the tissue will get deposited?
Yes, this is it, please.
Read it. Metallic particles get deposited in a burn mark due to contact with metallic conductors and 2 joule heat purities, etc. demonstrated by enzyme histochemistry. Metallic particles, for example copper, aluminum, zinc and iron, in a joule burn, thereby distinguishing it from ordinary and thermal burn, sir. Where is it written that the skin comes over the wire? This is
written in your lord's metallic deposit in it that driving into the skin, and it is written.
Sir, we had read that somewhere else in the locker, so we will not be able to go, madam, we have to sit here and we have to see what is in front of us.
Okay, sir, it is not written in it right now. I don't have time to read other books right now. Is there any other
book, please tell me?
But sir, in this we had written reference Modi textbook for 56.
Sir.
This means it is not that 42 which you have put in the last book. Death by electrocution, page number 167, the last page of your father's written argument. Forensic medicine and toxicology, this one the photograph which you have seen is made of metal Kogan with any place. In it there is a picture of a finger. Lastly, in this you want to tell something. Sir, it is not written in it right now. We will not be able to read it, right now time is getting wasted. We want to tell your lordship, sir, we knew this thing that there is lockard principle of law, in it there is mutual exchange. When the tissue worn those metallic particles go into the tissue, then certainly the tissue will list to the wire.
So you asked the FSL man, sir, I have given him
the application but the opportunity, not the application, madam, look, don't sing this song.
The normal presumption is that a lawyer before cross-examining the witness shall consult the client that is the accused and on instructions of the accused, the cross-examination will be carried out.
If the accused appears even through video conferencing, then the lawyer has the facility to take instructions from him. Sir, in our Chhatarpur jail, they used to call him just for signatures that today you had a hearing, you have been asked to appear. What is your name, Mamta? They just signed in the register and went back. It is
not like that, madam. The judge Sahab sees through video conferencing that he makes the person who has come from the jail sit and keep him there. You have made a mockery of the entire judiciary like this.
No sir, they are making us sign mistakes. It means that our judge Sahab became a party to it. No sir, you should have given an application that the cross-examination of vices is